Well, good afternoon, everybody, and welcome. And it's good to see so many people here. And one of the things that really makes me feel pleased are the number of students who've enrolled on today's talk, and in particular, those from the local universities in Birmingham, as well as the trainees from firms. And I'm very pleased to be involved in this particular type of training, which is intended to be experiential in the sense that ideally, teaching somebody to ride a bike, it's best to take them down to the park. Can't do that at the moment, for all sorts of reasons. So we have to do it this way, which you'll forgive me, is the less perfect way of dealing with training. My name is David Berkley. I'm the head of chambers of 3PB Barristers. We have a presence in Birmingham in the Como building, and we're one of the largest sets of chambers in the country. I think we're currently the third largest. We have over 200 barristers across 6 different sites in England, and I have the privilege of being the head, and therefore I see advocates across a range of disciplines, range of seniorities, and I myself have been a barrister now for over 40 years, and I've also been involved in teaching, and as well as having my own pupils and having seen barristers being nurtured through to become very fine advocates, I've also had the privilege of working with firms of solicitors, large and small, assisting them in relation to training as well. So that's my background. I'm going to now share my screen with you as we go through this. And you'll forgive me because this is going to be called an introduction to advocacy. I was asked by the Birmingham Law Society to speak, and of course, it's very difficult in just under an hour to tell you everything I know about advocacy. But we'll make a start and we'll see how far we get. And if anything, what I think you will find is that we're setting off on a journey, because one of the aspects about this type of learning is that you learn every day. And all of us continue to learn. I continue to learn. And I'm receptive to other people's ideas as we go through this. So if I help you to think that way, then we'll have done the job for today's purposes. So let me see if this works now. Yes, so there are many aspects of being an advocate. Being an advocate is more than just somebody who gets on their hind legs and speaks to a judge or jury or tribunal. Being an advocate is a privilege, and I want to just talk about a moment before we get into the details what that actually means. And one of the aspects of this particular type of discipline, being an advocate, is that there are many elements to it, and those elements are linked. And we're going to discuss some of those elements today. So I say that I want to start on the basis of a state of mind that all of us should have when we approach advocacy, which is to see it as a privilege. I remember my own pupil master saying to me when I was a very young barrister and I went to court one day carrying the Guardian newspaper, that was a very serious issue, because here I am going to represent somebody who's in a crisis, the most important day of their lives, and I'm carrying a newspaper. What does that tell them about my commitment to this case? So being an advocate, first and foremost, involves expressing in your own head first, before you even address a court, what it is to be an advocate, that you're representing people who are otherwise vulnerable or who don't have a voice, who are disenfranchised. And this isn't a statement. So I was saying that when one sees oneself as doing something where you're representing the vulnerable, disenfranchised, I don't mean by that everybody that you're acting for is not articulate, or that the person is necessarily coming from part of the society where they are clearly what you'd call vulnerable, because even a major corporation is vulnerable and disenfranchised in a sense, because it needs to be represented. It can't speak for itself. And therefore, your function as an advocate should never be denigrated. I would say this, that everything that's done, whether it's a large case or a small case, can be done well or badly. Every time you address a tribunal, whether it's only to ask for an adjournment, you can do that well or badly, as the case may be. And once you see yourself as a professional advocate, then every time you engage with the decision maker, whether that is the judge, the jury, or the tribunal, whoever it may be, you've got to consider, are you doing this job optimally? Are you doing it in a way in which you can say, well, you are a professional? And in order to appreciate that, we've got to recognize that advocacy really matters, that it makes a difference. If we didn't believe that we wouldn't be going into this business in the first place. And the reason that advocacy matters is because everybody is potentially prejudiced. Every fact finder doesn't come to any decision on a completely level playing field. There is always, whether there is subconscious or conscious bias that is going to exist, which your role as the advocate is to try to overcome. So to take an example, if you're a criminal advocate, you'll know what I'm talking about. You watch every day in the Crown Court where somebody is brought up from the dock. The fact that he's in the dock is already a prejudice, because there's no smoke without fire. The police wouldn't have arrested him and put him in the dock unless they had evidence. And when the jury are impaneled, and when they hear the 12 counts on the indictment that suggests that between certain days this man did have unlawful sexual intercourse with a girl under the age of 12, they're ready to convict him there and then. They haven't heard a shred of evidence yet. And so it's recognizing that is, I think, part of our function, that you see that you can win a case by persuasion, not necessarily by an appeal to emotion. Of course, it's important that we recognize the fact that human stories carry interest and that there is a genuine case to be made out for making an emotional statement. But ultimately, most cases are going to be won by a logical and persuasive argument. Now, the job we do demands professionalism. And I don't just mean the code of conduct or the regulatory codes that we adhere to. I mean the need to take responsibility. And I think this is something that particularly those who are coming into the professions will need to bear in mind, is that advocacy is the one area where it's very easy to deflect responsibility. It's very easy for the young barrister to come back from court and you say to him or her, well, how was your day? And he said, it was terrible. What happened? Well, we lost the case. We lost the case because the judge is mad, or because the witnesses went off proof, or because the solicitor's instructions were crap, or whatever it may be. There's 101 ways in which the advocate can say it's not my responsibility. Nobody carries out a post-mortem when the defendant is taken away to prison, or when the corporation loses millions of pounds. We've got to take responsibility for what we do. And again, it's seeing it in that way that I think is what makes this job so challenging, and also in many respects so meaningful, because you can take pride in the case. You can say you did that job well, irrespective of the outcome. You can savor the moment as you're lying in the bath thinking about that day in court when you were confronting the witness, and that series of questions that you asked where you got the witness to change her position in relation to a critical issue, even though it didn't ultimately make a difference to the outcome. You can still take pride, because at the end of the day, you're a professional. And if you have had a difficult time, the good thing about this job is you move on and don't beat yourself up. You just learn to do the job better, because being an advocate, once you start on this journey, is a lifelong commitment. So yes, who is going to be the advocate? Every one of you can be an advocate, because there isn't any model for being an advocate. When you think about it, in the days when you thought of the great Victorian advocates, you know, they were all 6'6", white, male, Oxbridge educated. These aren't the models for the ideal advocate. None of that equips somebody to be an advocate. Being an advocate means that you're effective and your size, your shape, your gender, your color, none of that matters. All of that is entirely irrelevant. In many respects, being an advocate is one of those areas which is the most meritocratic of all activities, because a good argument well presented is a good argument well presented irrespective of the perception of the person who delivers it. And so don't be worried about who you are, where you come from. It doesn't matter if you've got a regional accent, that works absolutely fine. But what this job is not for is for bluffers. Those hooray Henrys who command the attention in seminar classes because they've got a lot of confidence may have the advantage over you in the first few months of practice, but you know something, the courtroom is a great leveler. If you're in court and you're not prepared, or if you're in court and your case is being badly presented, or you're putting propositions of law which you cannot support, then you're bluffing, you're flying by the seat of your pants, and you're going to be caught out. And therefore what counts ultimately is your effectiveness. And that's all within your control. That's the good news about our particular professions. So you've got to know who you are. You've got to be honest about yourself. You've got to recognize what are your strengths and what are your limitations. If you don't make people laugh when you're in the pub, don't try humor in court. If you're worried that you have, I don't know, you tend to use your hands a lot in court, so what? Don't listen to people to say to you, you've got to stand like Prince Charles or keep your hands out of view in some way. Gestures are fine, provided it's not semaphore, provided that they're appropriate. And what you're doing in this self-awareness of who you are and what makes you a unique advocate, because each and every one of you has got specific elements to your personality that you can bring to bear in advocacy, which I don't necessarily possess. And so what it is harnessing that unique aspect of yourself. It's taking your own personality and building it up. It's personality plus. That's what we see in the courtroom, provided there's integrity to this process and you're not trying to be somebody that you're not. So one of the things that I believe in, and I think you believe in because that's why you've come on today, is that advocacy is not a talent, it's a skill. People aren't born to be great advocates. They may have certain qualities, as we've said, which they're going to be able to harness. And every one of you have got your own unique qualities. But ultimately, advocacy is a skill. And because it's a skill, it can be taught. And because it's a skill, there are certain things which we could call techniques, which can be demonstrated. And if they work for me, they'll work for you. And I'll try to, even though we've only got a limited amount of time today, I'll try to give you one or two examples of that in order to demonstrate what I'm saying. So yes, advocacy can be taught, but in order to be taught well, we've got to avoid teaching it in a prescriptive manner. You know, there's no right way. Students, particularly on something like this, like to think there is only one way. Just tell us what the secret is. Just give us the key to unlock this. Well, there isn't one. I don't want anything I say to you today to be thought of as being in any way prescriptive. If it helps you, it helps you. If it doesn't, move on. But what I'm going to give you and talk about is the need to identify what are called techniques. And technique is a Greek word meaning really a bag of tools. And that's what we're talking about. It's knowing what are the tools, where can you find them, and what is the appropriate tool for the job that I'm doing right now. And in order to learn this, because we're not going to learn it all today, or indeed this week, this month, or this year, it's learning every day through really a process which, like every other form of experiential learning, is done through building blocks. And as long as you recognize that you're on that sort of trajectory, then you're going to be enjoying for the rest of your professional lifetime an experience of continuing to refine and improve your advocacy over the years. So the key to this is to identify that universal principle, whether it's to do with witness control, whether it's to do with structure of speeches, whether it's to do with the manner in which you command authority in the courtroom. All those things are things that you can demonstrate, you can see, you can learn, and they conform to principles that are universal, that go well beyond the specific case or the facts of the case that you're dealing with. So you've got to work out what it is that works when it works, when something works. And once you start thinking like this, you'll find that every day you're listening out for this and you're watching what's happening. Why does something work? Why did it happen that in court today, that cross-examination was so effective because the witness felt so confined? Why was it that not a single question resulted in an answer which the advocate didn't intend to be part of the unit of information the fact finder was going to receive? Well, it's all to do with the form of the question. It's all to do with witness control. So identify what worked and see if you can see behind the presentation what was going on. Equally, when things go wrong, when things go wrong in the courtroom, somebody has to take responsibility, as I say, and try to identify, well, maybe the problem lay in, for example, the fact that something was introduced far too early, which should have been left until certain other facts had been established. That demonstrates that the advocate had not actually developed a proper case theory, not done an adequate case analysis, and hadn't thought about the sequencing of the evidence when he came to present his case. So this idea of learning every day, if there's one thing you're going to take away from this lunchtime, it's this concept, because we have the advantage, certainly in pre-lockdown, that we used to be able to meet our colleagues, meet our pupil master, pupil supervisor, or your principal if you're working in a firm of solicitors, and you'd have those discussions down the pub, at coffee break, whatever it may be, even just in the corridor. And it's that part of the collegiate, fraternal aspect of being a professional advocate. You can learn a great deal from that, and that's a given. But you can also learn from your opponent. Every time you go into court, because it's an adversarial process, you have the opportunity to see at close quarters somebody else's work. And I don't know about you, but I find that when I'm doing that, I'm listening critically to what's going on there and identifying those things that are being done well and those things that are being done badly. The one thing you should be careful of is, although you've probably used to being critiqued, maybe when you were doing practical studies at university or by your supervisors and that, but beware of the judicial compliment. One of the biggest problems I find, particularly with people who've in their first year out of pupillage, is that they get compliments from the judge and they misunderstand them. When the judge says that Miss So-so fought valiantly, what he means to say is that they were unrealistic in the outcome. When they say that you've taken every single point that could be taken, that might be a compliment, but it might equally be a criticism. So beware of the judicial compliment, because judges are not particularly reliable when it comes to critiquing, and therefore beware. What you need to do is to look at other professional people. Now, because much of what we do is an interrogative process, ultimately, much of what we do is asking questions. It's asking questions from people who are reluctant to answer those questions in order to be able to pass information from that person to the fact finder. And how do we do that? By asking questions. And who asks questions? We see every day on the news, on the Today program, on Newsnight, we see people being questioned. And it's just worth listening to how people ask questions, the form of the question. Was that a leading question? Was that a non-leading question? Why was the question introduced then? And this is, again, not saying that either Emily Maitlis or Nick Robinson are the people for you to listen to. I've put them in brackets simply because whoever happens to be the current presenters on these programs are themselves very often skilled interviewers and therefore doing your job of asking questions. So keep on practicing. If it's important, and it is, to know the difference between leading and non-leading questions, have a practice day where you only ask non-leading questions when you speak to your own family. See how that works out. Can you avoid ever not asking a leading question in the course of the day, in the course of your social interactions? Keep on doing these little experiments because ultimately that's what you're doing for a living. So let's look at the first stage, and it's a given. Listen, I'm not here to assume that any of you are other than very fine lawyers. And much of what I'm saying, I'm quite sure, is brought home in the course of both your training and within your firms. But clearly, preparation is a very key aspect of it. But preparation sometimes becomes a bit of a bind. And I've noticed that particularly, if I may say so, amongst solicitor advocates who've moved from being solicitors who've come into advocacy, the idea of not having the confidence is misplaced. I'll give you a very quick, very quick anecdote. I don't try to avoid these things, but look, I once had to train a very, very well-known firm of solicitors who would taken all their key advocates to a hotel, and we spent a few days doing very intensive training. And part of that involved doing a presentation to the client, where they had to analyze a case study which involved a few leave draft files and to tell the client what they thought of the case. And they did it very well. These people were absolutely fantastic. We videoed them actually. We actually recorded them speaking to their client, telling their client, what the strengths and weaknesses of their case are, and explaining why they think you're going to win the case. Excellent. We then said the next day to the very same people, in relation to the very same case study, we now want you to make a summary judgment application. In other words, to make an application, to explain to the judge why there's no real prospect of the defendant succeeding on the case, that you're going to get judgment. Now, they went into a panic suddenly, and they said they needed more time, they weren't ready, and so we gave them more time. And when they came to do the presentations, quite a number of the people who had been really excellent, they'd been flying when they were in the sort of client presentation mode. As soon as you put them into you're addressing a judge mode, which was the same people, it was just the same conference room being used for the same study, suddenly they felt that they had to use notes. They couldn't see their faces because their heads were down, because they were visually reading from their prepared notes. This is all to do with confidence. It has nothing to do with effectiveness. So preparation is important, but equally, preparation shouldn't be used as a form of perfection paralysis that stops you from going ahead and taking the plunge and doing the job. And I think part of that is that every case can be broken down. Yes, when you look at 20 lever arch files, with thousands and thousands of facts in there and hundreds of documents, yes, it becomes very unwieldy and you become, in a sense, overwhelmed. But every case has an analysis. You should have done a case analysis. Now, we haven't got time today to talk about case analysis. It's important to use a method of case analysis so that you've developed a case theory, because that case theory tells you why you're going to win the case. And it also tells you what are the key and essential elements of that, so that you're able to take all that huge bank of lever arch files and be able to tell somebody in 1 or 2 sentences why it is you're going to win the case. So preparation also means, because doing this job, as you know, it's stressful enough, you don't want to add to that stress by being disorganized. I always say there's a difference between if you think about it, of course, things have changed a lot since lockdown, but it used to be the case that I used to give this as a demonstration that in a trial, you go into court, you sit there, you assemble, and when all that's ready, when the judge is ready, the judge then parades in. And the first thing that happens is that you stand up and the judge is visible to you. When you go to the district judge's chambers in order to make an application and you're arrived because the bus was late or because you couldn't find a parking place, You get there just before the case is called on, and the usher's pushing you into the room, and you wander in looking like a burst mattress with all your papers spilling over. The first thing the judge sees is you. So all these things can be controlled. It seems obvious, but make sure that you're, if anything, arriving too early, that your documents in place, that you know all the relevant things that are taking the stress away. So look, write down your opponent's name. You know, very often the first thing you have to say to the judge is, I pay for so-and-so, and somebody else pays for the other person. You might have been playing, you know, golf with them the day before, but you're going to forget his name or her name before the case even starts. Know these things, have everything in place. These days we're using electronic bundles. Familiarize yourself with the bundle, with the hyperlinks, with the tabs. Understand where the index is to be found. And if there's too many documents to handle, then suggest that there be produced a core bundle. Make things easier for you. If the case involves, for example, having to prove a series of transactions based on a course of dealings, there may be 3,000 invoices. No one's going to look at 3,000 invoices in the course of a trial, but they will look at a table which you've prepared, which brings all those elements together. And provided that you've identified where the documents are to be found, no one's going to take you to task on that, because they'll trust you, and you will be trusted because you are a trustworthy person. That is a, provided you've not ambushed anybody and given them due notice of this. These things, plans, any aid at all that shows that you're demonstrating preparation, demonstrating that you can come to do what's really important, which is move towards argument and witness handling, that's key. So understand who the people are, not just your opponent. Who are the witnesses? What are their names? What's the cast list? Now, it may seem obvious, but one of the things that I've always suggested to people is, leaving aside what you might produce, skeleton arguments, chronologies, all these things, have your own pocket brief available close at hand. On that document, which should be a single sheet of paper, you've got the key dates, the key people with their names, because you'd be surprised, even some very good advocates have the tendency to either forget the key dates or even use the wrong names for people. And often if that creeps in, it'll keep on repeating. And every time the witness has to correct the advocate, that's not good advocacy. That's not good persuasiveness. So have the timeline, know the key dates, and be ready to help the judge. If the judge needs help, you become the ally of the judge by providing that information in an appropriate way. So the law. I said, I'm assuming all of you are fine lawyers, and indeed you are, but the law is has a very interesting part to play in all of this, because in my experience, the law can also be dealt with in a way that is not persuasive. People often use too many authorities. They hide their weak case in a whole dumping of material, and also they do things like quote unnecessarily from large tracts of judgments, because that's easy to do, to read a judgment out to the judge. No, identify the key propositions of law. That's what's important. The law is part of the reason you're going to win the case. Identify those key propositions, be familiar with the necessary authority so that you can speak to them if necessary, but most importantly, be able to summarize accurately and confidently, with authority and with economy, what it is that you're relying upon and how you deal with your opponent's case in relation to the law, because that's equally as important. So a trial typically, or even an application made on the most procedural basis, usually has an opening. Even if the opening is just to introduce yourself and to say that an opening is not necessary. But being the person who opens is a privilege. It's a great advantage to be the first person to actually be able to stamp your own personal authority in the courtroom and become, in a sense, allied with the process. So learn to speak in opening from your client's perspective. Now, what I mean by that is that even though I would encourage that in an opening, you do not get involved in excessive argument because you don't know how the case is going to go yet. Your job in opening is to identify the issues. And of course, much of this is done by reference to skeleton arguments today. But nevertheless, if you get the opportunity to provide some personification for your client, because your client ultimately, is a person, he or she has a name, and that person is here to seek damages because they were injured in a road accident which was not their fault. And the insurers accept that it was not their fault. So you've got an ability, without over-laboring it, to create in that opening that climate of empathy. But remember that no one's heard any evidence yet. And so don't overpromise. Don't say you're going to hear this and my client's very credible and you will believe her, because that may not be the case at all. So one other point about openings, even though the judge says he's read the papers, and even though the judge has had the opportunity to do so, don't assume knowledge on the part of the judge that you've got and your opponent might have, but the judge is not likely to have. In fact, one of the criticisms that often is made from over preparation and over long openings is that it puts far too much information in front of the fact finder, whether it's the judge, the jury, whoever it may be, at an early stage. Nobody could possibly be able to cope with that. So avoid that information overload. And if anything, if you want to think about it, if you're able to narrow the issues in any way, if you're able to give the judge some good news that he or she is not going to have to deal with a certain issue that otherwise might have been very much in play, that's something which the judge will be delighted to hear. So there is room for making concessions, but you'll see that I've added the word appropriate concessions. There's nothing worse than thinking, have I made a concession about something which I should not have done? We're not doctors, but doctors have what's called the Hippocratic Oath, and that is do no harm. And we should have the same promise to our clients. We can't promise that we'll win the case. We can't promise to them that everything's going to go well. What we can say to them is that we will do no harm. And before you make any concession, just think through what that means. Play it over once again. And if you need to, bring the client with you, explain to the client what the concession is, make sure you're authorized to make that concession, because once you've made it, it's very difficult, as you know, to resile from that position. Okay, I'm going to now say a word or two about witness examination. I know that's what many of you consider advocacy is all about. That's the sexy side of advocacy, all the, I put it to you stuff and all the stuff one sees on television. But in fact, witness examination, as the advocates here will know, is only one part of all of this. But witness examination involves many techniques. And as I said before, I can't possibly try to condense into this short talk, this presentation, the sort of techniques that one learns and goes on learning in the course of a career. But let's see what we can do. The first thing I would say is that we tend to think, those of us of my generation, that the first thing the witness does is the witness provides his or her evidence in chief. And when I started off, that was done in a conventional way. We didn't rely on witness statements. The witness would go into court, into the witness box, take the oath, and then would be asked a series of non-leading questions. And one, in a sense, the case could be won and lost at that stage. Today, we do it differently because people generally rely upon the witness statement as the evidence in chief. But it's important, though, to understand what non-leading questions are. And non-leading questions are going to come back, I think. Not only are they important because you sometimes do have questioning in chief before cross-examination, which has to be non-leading. You also have re-examination at the end of a case, where again, the rule is that you can only ask non-leading questions in re-examination. But another reason why non-leading questions or open questions is going to become more important is because of the very new practice direction that's come in April, which is 57AC, which is the practice direction dealing with how witness statements are to be prepared. And it's specifically directed in that open questions should be used, in other words, non-leading questions, and leading questions should be avoided. Now, there's a very good reason for that, and I'll give you a practical illustration. If I want to know whether my friend is happily married, I could say to him, "You're happily married, aren't you?" And he says, "Yes." And I write down, "I am happily married." I could say to him, "Are you happily married?" He says, "Yes." And I'll write down, "I am happily married." Or I could say to him, "Tell me, describe to me, what's the current state of your marriage?" I don't know what the answer to that will be. Depends really what I want to know. What I'm pointing out to you is that I've demonstrated the same unit of information being extracted first by a clear leading question, second by a midline leading question, and thirdly by a completely open non-leading question. And the difference is that once the witness, when you look at the witness statement, you've no idea from the witness statement what question was used in order to arrive at the narrative response that we can see on that document as a statement of fact. And of course, if it's been asked by leading questions, then as soon as it's being tested by a cross-examination, it might all fall apart. Hence, it's not just a matter of ethics, it's a matter also of practicalities. One of the many reasons that witnesses find it difficult in the witness box is because statements have been prepared where the solicitor or the statement taker has asked closed questions or leading questions, results in the witness finding it difficult to continue to be wedded to that answer or the unit of information that appears as a sentence in the witness statement. So if you want to learn the techniques of non-leading questions or examination in chief, I haven't got a great deal of time today to deal with that, but obviously one thing I would suggest is, first of all, plan a structure. Ask yourself, what is this witness coming to tell the court about? Plan that in advance. Then think about using single fact questions. They're the most effective way of keeping the witness under control. Keeping a witness under control when you're asking non-leading questions is the most difficult because you're giving the ball to the witness all the time. And don't be surprised, therefore, if the witness takes the ball and runs. So you have to be careful how you deal with that, how you confine a witness, whilst at the same time not being able to use the maximal control that comes from leading questions. So single fact questions is a good idea, and also transitions. Transitions are these. When you say to the witness, "I want you now to tell me what it is you saw when you first came through the door." Now, have I asked him a question? No, I haven't. No question has yet been asked. What I've done is I've provided a headline statement that lets the witness focus on what will now be the series of questions, which he knows is a series of questions about his observations when he came through the door. And when I say to the witness, "Now, when you say that the window was dirty, I want you to tell me precisely what you could see." What have I done there? I've not asked a leading question, but I've used the word, "I want you to be precise." I've given a very clear indication to the witness that what matters now is important in terms of the detail that the witness now provides. So there are various methods we do by using transitions in order to help make sure that we're getting the maximal information relevant to our case, which, for having done our case analysis and case theory, and we do that sometimes using these techniques. And another technique that I'm going to mention briefly is what's called the loopback technique. So let's say that the witness in question, the point is that the witness in question was wearing a red carnation. Now, your problem is you can't lead the witness. So as soon as you mention red carnation, someone's going to object. That's a leading question. You know, what did you have in your lapel? I object. Why? Because you're assuming he had something in his lapel. So you've got all these problems about how you avoid the leading question on what is the fundamental issue. So you ask the witness, what were you wearing that day? Well, and he starts giving you the list. His jacket, his trousers, his shoes, his shirt. And then you loop back and you said, you told us you were wearing a jacket. Could you describe the jacket? And then what you're doing, you're looping back always until you get to the point where ultimately you hope you've got the answer to the very question that is that you need answering, which is critical to the case. So that's just a few brief techniques in relation to examination in chief. The general rule is that any question that begins where, when, how, what, describe, or explain is likely to be non-leading. In fact, it's very difficult to begin with any of those words and to convert that into a leading question. So it's, in some respects, the form of the question will always tell you whether it's leading or non-leading. And if you're using single fact questions, then those work very well with the where were you, what time of day was it, and so on. Now, there's a difference, isn't there, between some of those questions and the questions describe or explain. Describe and explain gives the witness much more freedom, but sometimes it's necessary. Sometimes it's necessary to allow the witness, because the witness is going to be well placed to do that. So let's say you're doing a case involving interconnector parts used for particular units within electromagnetic processes, not subject you know a great deal about. And you want the witness to now tell you about the particular part itself and whether it fitted or didn't fit. So saying to the witness, asking the witness, having framed it, to then to describe and then to explain something and then to ask the why question. Why is that important? That's not a leading question. Why is it important that those two elements, that's the male and the female components, should fit? Why is that important? And he'll explain, because it's absolutely fundamental to the operation of the machine. So you can see how different forms of questions, using the right form for the right piece of information or series of information. So I've given you examples of where single fact responses are what you're looking for. I've also given you examples of where inviting a narrative response from the witness is also appropriate. But you decide that, because you control the flow. That's what advocates do. We control the flow of the information all the time. Let's talk about cross-examination. And I think, as I've already pointed out, in cross-examination, maximum control is achieved through the use of leading questions. And although we talk about cross-examination as if it's somehow destructive of the witness, it doesn't have to be. In fact, the likelihood is, before the witness came into the witness box, the witness probably had the perception that you were going to be coming in order to undermine her or discredit her, whereas in fact, you may want to be entirely supportive of her. I'll give you an example. Let's say she is the secretary of the managing director, and it is said that she made a contemporaneous note of a conversation, and you want to rely upon that note, because that
Hello everybody, and thank you very much for attending this meeting today. Obviously we have Denisha, Hannah and Tasha present, and I have received apologies from Becky.
So here is a witness who's been called for one particular purpose, but you can say to that same witness, you've been the secretary of Mr. So-and-so for 40 years, haven't you? Yes. And you're good at your job, aren't you? I think I am. And one of your jobs is to make sure that you make a memo, a record of his telephone conversations when you are there in the room with him. Is that right? Yes. So what you're doing at the moment is you're entirely supportive cross-examination. The beauty is that you can ask as many leading questions as you want. You know exactly where you're going with this. And it's certainly not for her boss's benefit that you're asking those questions. So supportive cross-examination certainly has got a place. We emphasize all the time in advocacy as if it's a one-way street. It's about us. It's about our ability to communicate. But it's not only that, it's also our ability to listen. And I think one of the things that I've noticed about the very best advocates is they recognize that, first of all, the courtroom, it's a dynamic process. Things happen all the time. Answers are given that may not have been expected. And if somebody has just prepared a series of notes, if they've just prepared pre-prepared questions, you might as well just send a questionnaire to the witness. Part of the process of your engagement with the witness is having the respect for the witness and for your own case of listening to what the witness's answer might be. And if it means stepping outside of the comfort of your structure because it's too good to miss, take it, take that opportunity. I want to say a word or two now about impeachment of the witnesses, because that really, as I said, I wanted to say a little bit about techniques. I want to give you one or two techniques maybe before we finish. One of the things I notice, and I notice this very much when I'm sitting as a judge, so I also have the privilege of sitting as a judge part-time, and therefore I hear a lot of advocates who appear in front of me, some good, some not so good, always very interesting. Now, one of the things people try to do is to impeach the witness, discredit the witness, and there are probably two classic ways of doing so. The most obvious way, or the most effective way, is by reference to an inconsistent statement. You said this today, you said something else another day. Those two things don't exist in the same world. That is classic impeachment by inconsistent statement. And it's an extremely effective means of impeaching the witness. Now, what's less effective is what's called impeachment by omission. You made a statement. In that statement, you don't say that it was raining. You've told the judge today that on that day it was raining. You're lying. The witness will say, well, it doesn't mean I'm lying. I just didn't think it was important at the time. Well, nobody asked me. But now you're asking me, I'm telling you it was raining. Inherently, impeachment by reference to omission is never as effective as impeachment by reference to inconsistent statement. Now, I say this because even in the most standard fast-track trial, far too much time can be spent without much effect in examining the witness in what's not in his witness statement as opposed to what is in his witness statement. But coming to the classic form of cross-examination by reference to inconsistent statement, let me just leave you with this little idea. Because again, it can be the making or breaking of a case. And sometimes we're too eager to introduce it. Let me say to you, for example, that let's say that the witness statement says something that's inconsistent with what the witness has just said on a material critical point. The witness has said something in the witness box that is inconsistent with his witness statement. So it's very easy to just immediately tear in with that witness statement. And the fact of the matter is, if you do that, one of two things is going to happen, I can assure you. One of two things will happen. Either the witness will say, no, I didn't mean what you say. Well, what I said in the witness box, I was under pressure, I didn't mean it, you've misunderstood me, whatever it may be. The witness is either going to rubbish what he said in the witness box, or he's going to rubbish what he said in his witness statement. He's got two belt holes, you see. The other belt hole would be to say, well, that's my witness statement, but that was done, my solicitors wrote that actually, and yeah, I didn't pay much attention to it when I signed it, and so on and so forth. So just putting the two statements together is not as effective as using what I call the 3 C's method. What are the 3 C's methods? So here is a technique. If it works for me, it'll work for you, and it'll work every time. And people will watch it and say, that was brilliant, but it's not brilliant, it's just using a technique. So the first C in the 3 C's method is to commit the witness. To commit the witness to what they've just said. So have I understood you correctly? You told His Honor that, XYZ. Is that correct? Yes. However you want to put it, it's the first C is commitment. You have to commit the witness so that the witness now is fixed on that point. They've just confirmed that with you. What's the second C? The second C is let's establish the circumstances of that earlier statement. Do you remember you made a witness statement in this case? Yes, I do. Do you accept that when you made that witness statement, it was closer in time to the events you described than today? Do you accept that? Yes, I do. And do you accept that you made that statement with the assistance of your solicitor, didn't you? Yes. That's the same solicitor who now instructs you, who you've now retained. Yes. And do you accept that you had every opportunity to read that statement? Yes. And that you took it? Yes. And that you read it and that you signed it, etc., etc. And that represented the truth. And you wanted the judge to accept that as the truth of yours, of the account, etc. However you want to do it, you have now established it. Now, what I've not yet done is I've not yet confronted the witness. Have you noticed? I've not put the statement to him. That's the third C. The third C is confrontation, confronting the witness with the fact that he's got nowhere to go. And that's just doing the same thing that I would say works for me, works for you. It's the 3 C's method. You can take that with you as a gift from me. Use it the next time you're dealing with an inconsistent statement. So the one thing that you need to be aware of is that your demeanor and your own attitude in court is very important. You know, contrary to what people sitting behind you may think, or your client may think, the finger jabbing, finger pointing type of advocacy doesn't necessarily play out well with those who are having to make their decisions. You know, they will see the advocate and wonder, why is the advocate being so cross? Why are you getting so emotionally involved in this? Ultimately, you're a professional and you're doing your job well. And so the last thing that cross-examination is about is being cross. Because if you are, then the only person who's going to be seen as the victim will be the witness. And that's not the sort of imbalance that you want to try and achieve in witness examination. And finally, you've got to find the point where you and the witness can agree. Let me tell you what I mean by that. Every time you confront the witness in cross-examination, you should know where this is going to go, because you're asking leading questions, you've got a case theory, you've developed a structure, you know exactly what the sequencing is, and you should know where you're going to go and where you're going to end up. And if it goes well, as it should go well, then you should ensure that by the time you've moved on from that particular unit, that you're on top. If you're not on top, then you've not done the job correctly. So let me give you an example of where you and the witness must agree. So let's say, for example, it's an issue in the case whether or not the witness had called her sister in Australia at 3 a.m. on the particular morning. And you put it to her, the leading question, you called your sister at 3 a.m. on the particular morning, didn't you? And the witness says, well, I didn't. That's not the answer you wanted. And if you're going to move on from there, then as far as I can see, the witness has ended up on top. But how about this? Okay, but you do agree, don't you, that you were at home in the early hours of that morning, weren't you? Yes. And you do have a telephone, yes, and it was working, yes. And you do have a sister, don't you? Yes, and she lives in Australia, doesn't she? Yes. And so you had every opportunity at 3 a.m. to phone your sister, didn't you? So you see that? We haven't agreed, but I've not debated the issue with the witness, and we've ended up with that particular unit where it doesn't sound to the jury or to the judge or the fact finder that the witness somehow or other was on top, because in cross-examination, that should never happen. So, the other thing that I just want to caution against, because we're running out of time and I wanted to cover as much as I could today, is that one of the reasons things go wrong and why you end up debating with witnesses is because you ask value questions. If you say to the witness, you had a lot to drink, you then start arguing about what's a lot, I had 8 pints, that's not a lot for me, it's a lot for you, whatever it may be, you know, you're going fast. everything should be put into, if possible, empirical form, if you can, to avoid the sort of debate and discussion that we're seeking to avoid. So very quickly, I'm going to move on. I haven't got time to deal with re-examination or indeed closing. I just want to talk finally in the last few minutes about this point, which is commanding authority, because I think particularly for young people coming to the profession, I think it's always useful to end on this. If you are a barrister or a solicitor, any form of professional advocate, you have the advantage that the judge, whether the judge knows you or not, that judge, she thinks that you are a member of a profession whereby you've got a way of conducting yourself which is based upon your capital of goodwill. Let me tell you what I mean by that. Whether you know it or not, the difference between you and a litigant in person or an unrepresented party is the judge assumes when you step into court, whether it's the first time you've been before that judge or not, you've already got in your bank account a deposit based upon the fact that you are a solicitor or you are a barrister or you are a paralegal or you are a trainee, whatever it may be, that you're coming into court with a capital account which is in credit when you step into court. And that's very helpful to you because things do go wrong. You can be late for court. Things can go wrong with the disclosure, but you've got your capital of goodwill. So you can draw upon that occasionally, provided you're not overdrawn. And you can become overdrawn very quickly. And you can become overdrawn because, for example, you're not seen as somebody who is entitled to the full capital account. And that's how you behave in court. So if you're, for example, excessively using objections, you may be thinking you're doing this client a great deal of good, that you're doing the job that this client is paying you to do, but you're drawing excessively on your capital of goodwill. You may want to take risks. It's never worth it. No client, leaving aside the fact that people should behave ethically as an end in itself, but even in terms of wanting to have a lifelong commitment to advocacy, wanting to know that whichever court you go into, particularly if you have a local court that you go into, you want to maintain your capital in your goodwill account pristine. And if you have to draw upon it, the more that's in that account, the better it will be for you. So, ladies and gentlemen, I think we're approaching the hour, and it's been a bit of a gallop, and you'll excuse me for the problems we had initially with the technology. I'm going to stop sharing my screen now and see that we have still got a number of you still here, so you've not all departed. But thank you all very much indeed for attending. I won't be able to use this opportunity to answer questions as such, but if you ever invite me again and there is an opportunity to do something a bit more interactive, perhaps when the lockdown ends, I'll be happy to try and assist. But thank you all very much indeed. And I don't know who is hosting this, but I'll say my best wishes to you all and wish you every success in your future careers. Thank you very much indeed.